So the floor now is yours. Let me suggest there's two ways you can ask a question. If you'd like to boldly come to the microphone and ask the question, it's right over here in the front. For those of you who would like me to ask the question, I think you all have index cards or can get index cards. Please feel free to hand it to Mr. Brescia, the director of the Government Law Center here at Albany Law School. So what comes first? Does someone want to ask a question or give Ray a card?
Somebody raise their hand.
Come on down. Oh, okay.
Yeah, you've got one of each.
Yeah, I'll come with some more.
Oh, it would take me forever to claim.
Yeah, I have a simple question that might support Mr. Rifkin's view here. And it has to do with ethics enforcement. Now, I was a long-term civil service employee of the Public Service Commission. On the first day on the job, we were given, there you go.
I'll hold it up. I'll hold it.
On the first day of the job, we were given a copy of the New York State Public Service Law and a copy of the Rules of Procedure. And it said we cannot have any investments in any utilities or anything related to a utility. You couldn't own something like General Electric Company. An employee took that to court, challenged it, and the case was thrown out. We also had other rules that you weren't allowed to take a cup of coffee from a utility. Employees were disciplined for taking a cup of coffee and some other things. So it seems to me there is an enforcement mechanism under the New York State Constitution already. Now, I don't object to, when they passed the Securities and Exchange Commission laws in 33 and 34, Felix Frankfurter and others said we should put a spotlight on the transaction. So you could do that with the state constitution. But as far as law, I'm not a lawyer either. It seems to me you have to have an administrative law and a rule and regulation to enforce anything. You can have all the language you want in the state constitution. So without a proper administrative law, I don't see how you accomplish anything. So my real question is, isn't it already in New York State, in the New York State Constitution, that we can discipline employees and regulate their behavior, such as investments or who your law firm or your consulting firm represents? So that's my question.
Yeah, I'm thinking Carl or Richard, that piece of it.
Yeah, it's Section 74, which was created back in 1954, has general propositions about ethics. To the extent you're talking about utilities, there are some sector-specific rules that prohibit gifts, and there's a zero tolerance. For example, in the Public Service Law, I think it's Section 25 or 23, anyone who works for the Department of Public Service or the PSC cannot take anything from anyone who's a regulated entity, and I think there are provisions there with respect to stock ownership. That theory and that thought has kind of evolved over time. The same rule used to apply to judges, but it became difficult when, for example, the Southern District of New York, when a judge was working on a case involving Microsoft, and he had a mutual fund that owned Microsoft, he would have to recuse, or she would have to recuse. So if there's de minimis amounts that you own, you can't really control the company. That is kind of the rule of the day. But there are rules prohibiting gifts, and when it gets criminal is when you start to get into a quid pro quo situation, and that's when you have bribery, bribe receiving, and issues like that. So, a lot of these things are fact dependent. Some things rise to the level of criminal activity, but can still be violations of the ethics law. I mean, if you remember the case involving Alan Hevesy, he was originally prosecuted or alleged to have violated the state ethics law, Section 74. That report was turned over to the Albany County District Attorney, who prosecuted him for a felony, and he won after being alleged to have violated the ethics law, he then went to the polls, he won by 18 points. So I'm not sure what that says, but he never took office, and people sometimes forget that because he pled to the felony, and that's how we ended up with our current comptroller. Richard?
Yeah, let me prevent Bill from asking his question. With regard to each agency of state government can go further then the ethics laws go. For instance, when I was in the Attorney General's office, we prohibited our attorneys from having any outside practice. Now, you can under the ethics laws, but that was a rule that the Attorney General imposed. And in the same way, the Commission can impose additional rules. The rules that exist in 73 and 74 are general rules. They're applicable to employees of all agencies, as well as the legislature and legislative staff. And they're enforced now by JCOPE. They've been enforced now the third of the enforcement bodies. And let me just say this about putting it into the Constitution. You can put this into the Constitution, but the effectiveness of enforcement by that agency, JCOPE now, will be no better than the funding it is given. And if it's not given adequate funding for effective enforcement, it can be in the Constitution and it will still never work. So I'm not sure that that necessarily is the solution.
Mr. Collins?
First, it's not true that I left elective office on a school board because Blair and Barbara were my constituents. It's not true. They were intelligent constituents. I appreciated having them. One of the issues that we face, I think, is not so much adjudication of ethics issues as it is investigation of ethical conduct. What we found is that we had to sit back and wait for Preet Bharara because we had an Inspector General's office that was pretty much under the control of the executive branch. We put into place a Moreland Commission, and we were petrified that it was going to actually investigate and find something. So its purpose, instead of investigating and find something, became bludgeon the legislature into sweeping ethics reform. And when it achieved that purpose, it was good to get rid of it. I think the investigative function is something that could conceivably be a constitutional amendment. You'd be surprised, anyone except Senator Dunn and Assemblyman Borowski, about the lack of control that the leadership has over very many functions of individually elected officials. Assemblyman Borowski alluded to the fact that, you know, if 130,000 citizens get together and think somebody should be an assemblyman, it doesn't, or assemblywoman, it doesn't make any difference if they're on the brink of indictment or the brink of conviction of a felony. That's their decision. And their decision puts that person in office. The oversight of that person in office, their travel, you know, when they should be allowed to travel, how much travel they should be allowed to do, is really not the leadership's responsibility or function or authority in some measure. It seems to me that maybe room for a constitutional amendment here may relate to an Inspector General function for either the executive or legislative branch or both, maybe an elected position of some sort. Maybe we get past waiting for Preet Bharara to act and stop focusing on Wall Street or wherever else, and we get into the business of a real look and examination of what's going on in government, what's going on in those public offices, how are they being conducted. We don't have presently, no offense to anyone who's serving that function, we don't have presently effective enforcement in the Board of Elections. We should have a lot more examination of filings. We should have a lot better law. 14130 of the election law should be amended to deal with private use of political funds. In theory, those are two separate legal entities, the candidate and the candidate's political committee. In practice, they get folded together quite regularly because the law is inadequate. But somebody should be looking at that. And it seems to me that the adjudicatory function, that's, you know, could be handled better. It could be handled in ways that's not so Byzantine in terms of how a particular house can keep someone from being
adjudicated. A constitutional investigative office to look at ethic violations in all of the state government.
Yes, sir.
Yikes.
I know you're afraid of it, but you've always been afraid of things in this, Senator Richard.
But there's a fair distinction between law enforcement and ethics commissions, and one of the difficulties, I think, and I think Richard and I have talked about this many times over the years. There is a big difference between the FBI, the state police, the sheriff's department that have handcuffs, guns, the ability to do eavesdropping warrants, grand juries, subpoenas, and the things that they can do, the tools in their toolbox, but also on the other side of that, the Bill of Rights and the constitutional protections that citizens have when they're on the other side of that. it's very different than an ethics commission, which does, I had one investigator for every 80,000 state employees. And I only had the executive branch. So, go out and find corruption, guys, and they don't have any law enforcement powers or anything like that. The core best purpose of an ethics commission is to be a resource, almost like a law firm, for those in government to be able to come in, ask questions in a confidential way and say, I'm thinking about this. My neighbor's going to the Yankees game. He has business in our agency, but we're best friends since childhood. Can I go? Things like that. I used to love getting those questions because it meant to me that there were people out there who had ethics in the forefront of their mind on a daily basis. And we could help them through the issues and make sure they didn't make the mistake. When you get these laws that get so convoluted that they become difficult to understand, and then someone makes a mistake, and as they say in law schools like this, you can't unring the bell, everybody ends up in a bad spot. David Patterson going to a Yankee game. That's, the governor of the state of New York should be able to go to a World Series game. I'm sorry.
Yeah, let me say that I totally agree with Carl with regard to the appropriate function of an ethics body. Unless you're going to totally give it a major enforcement unit with all the tools, and nobody's talked about this, and I'm not sure it makes sense to do it, it will never be a true enforcement body in the manner in which people talk about. And what an ethics commission can do is help those who want to follow the laws. And I'm convinced that the overwhelming majority and percentage of state employees are interested in acting honestly and in accordance with the ethics laws.
I don't know.
We help.
I don't know how I come down on this issue, but it illuminates the fundamental question before the House today. These are all good ideas. Are they constitutional ideas? And it seems to me that what's emerging, at least as I heard it, is a sense that the constitutional provisions can't get bogged down in details or in flexible language, that they have to be aspirational and broad and set institutional arrangements, policies, and a tone which informs the legislative and administrative processes. If that's the case, then the done fiduciary duty idea, the notion of a revamped Board of Elections that deals with campaign finance, the requirement of a campaign finance law, those are the kind of things that emerge as constitutional issues, more so than the individual elements of a particular proposal.
So we received a question from the floor that wanted to drill down on the delegate selection issue, which was how could you create a delegate selection process that would attract more of the kind of people that you have in mind for a constitutional convention?
That's an extraordinarily good question, and I think comes from one of my members.
It's a plan.
Yeah, it was a plant, as you know, dozens of people here are planted. And that's something that we are currently really trying to double down on ourselves. When people stop to really look at a constitutional convention, first of all, it's time consuming, number one. They would meet probably for, what?
4 to 5 months.
4 to 5 months, but 4 to 5 months for 1 year or for 2 years?
Usually 1 year.
1 year.
Start in April
well,
and the end of summer.
Well, okay, 4 to 5 months. I don't know how many people are really willing or able to take 4 to 5 months off to participate, except those people who are already committed, such as legislators, to doing that type of work. Or maybe law professors. Maybe they could get sabbaticals to do that. Retirees. That's the other thing. It's much like
Students.
Then comes the issue of what are they going to get paid, because the Constitution requires them to have, at the moment, the same salary as a sitting legislator, which is $79.5, maybe more by then. There is a wage commission that's working. So could we get good people? Yeah, we probably could with just some of the things we just said. Do we get half and half? I mean, and how do the delegates get selected? Will they be 3 from each senatorial district, as the Constitution currently dictates? And how would they run? Who would supply the money for them to run? Would it be public financing, or would they have to fund their own campaign? And then you've got a lot of the issues that people might want to run because they care about the environment, or they care about education, or they care about pension relief, or any of the other issues that'll come before a convention. So these are still the issues that we're really looking into, and we haven't come to any really concrete answers yet. And if anybody on the panel, anybody has some really good input, we'd love to have you be members and participate in our discussion.
Well, Assemblyman Brodsky, I think, authored legislation in the 90s.
Public finance,
Yes.
giving each voter 1 vote instead of
That's
3
right,
votes in the
instead
Senate races are the 2 best ways to do that.
And we have looked at both of those, yes.
I'm good. If you believe that those excellent, smart, wonderful people Blair Horner just described as members of the legislature are those same bums that you don't want anywhere near the convention, you have to be careful, because you can't disqualify a citizen from voting. But you could pass a law that said you can't hold 2 offices. That's the shrewd way of disqualifying all those wonderful people from candidacy or service.
And just very quickly, for those in the audience who are not familiar with the process, if November 2017 the electorate votes yes for a constitutional convention, the following November persons would stand for election as delegates. The Constitution would require that there be, given the number of senatorial districts that exist in New York today, 204 delegates. The Constitution requires 3 delegates be elected from each senatorial district and 15 delegates elected statewide. The question of how you would alter that process, the Constitution requires those bare facts, but what you could do to amend that process to allow for a people's convention has been the subject of debate. Assemblyman Brodsky's leadership in the legislature going back to the 90s on that issue. I'm sorry, you've been waiting very patiently.
Okay, no problem. My question has to do with pension forfeiture, and I think it's, in my experience in state government, except for the paycheck you get every 2 weeks, the most important thing to state employees or any local government employees, all the way down from a mail clerk up to the commissioners or the legislature or the governor, is their pension. Everybody is focused on that. And the thing right now stopping any realistic pension forfeiture provision is that constitutional protection of pension benefits. You can't do pension forfeiture unless you change the Constitution.
That's not true.
So I guess my question is I think that the legislature itself has not really ever enacted good pension reform.
That's not true. The newly elected members of the legislature are subject to pension forfeiture.
Yes, it's prospective, and it's only recently that was passed. Everybody else in state government, you got 100,000 people that are already there, and they have to make a decision on whether or not they're going to engage in corruption. It's a personal decision that each individual person has to make. And if their pension is an issue, that's going to reach, I think, a greater number of people and prevent more corruption. And instead of detecting it and punishing it, people are going to think 3 times about engaging in corruption if their pension is on the line, and that's for them and their families, whatever their beneficiaries are. The legislature has, and I know that this is the case, they've used the fact that the Constitution protects the pension from really saying, oh, well, we can't do anything about existing employees, so they just let that issue go. What's the chances, and I don't know how anybody's going to answer this, but if the legislature or the people who would be involved in the Constitutional Convention would have to put their own pensions on the line by changing this. If you were to say, okay, pensions can't be touched except if for a felony committed in public office, something like that, how are you going to get anybody in a Constitutional Convention to agree to a provision like that? Can it be done, is I guess my question.
They've already agreed for new ones.
That's right.
See no reason they wouldn't agree for others.
And not everybody at the convention, I guess, would have a pension at risk, depending who they are, right? I mean, if I was elected, I don't have a pension. I work for NYPIRG.
So I guess that's the answer.
But I mean, on the issue of the various organizations that have worked on this support pension forfeiture. But I would think, again, I don't know, I mean, I've never faced this, but I would think wearing the orange jumpsuit would be a very persuasive argument not to engage in corruption.
Why don't we just shoot them?
Well, I mean, you know, prison is scarier to me. If somebody said to me, you have two choices, you can lose your pension or you could go to, you know, you live in a prison for a while with an orange jumpsuit, I think I'd lose the pension.
The answer relates to the prior question about delegate selection. I think the more you can get a convention that's composed of citizens who are not members of the pension system, the more likely you're going to get the change. So I think the two questions are really pretty closely connected. Is it going to be, if there is a convention, is it a convention of citizens, that is to say non-current public officials, they're not going to be invested in protecting the pensions. So I do think the two questions are actually pretty close.
Well, and actually, as most of you know, the Senate has already passed a pension forfeiture constitutional amendment. The Assembly is looking at it, and the Assembly's is broader, and they want judicial discretion, and they don't want it as broad as everybody out there in the world of workers, state workers, rather than just elected officials. So that has yet to be decided. The Speaker, Mr. Hastie, has said that he anticipates this will get done this year. It would then go on the ballot, have to be done next year, I guess, and would then go on the ballot at the same time as the question for the constitutional amendment would be on the ballot.
Thank you very much.
So we have time for one question or two at most.
Okay. I'll try to get this out. I have a bit of a cold. I think Richard had summarized some of the appropriate things to be considered in a constitutional convention. But one of the things that he did not bring up was a point that, or a suggestion that Carl brought up about extending the length of terms to 6 years. Of course, it could be 4 years or some other term. I was wondering what the panelists thought about that notion. There hasn't been any discussion of it, and
I left it out,
they're
Tom.
both they're just one place. There, arguments on both sides. It's more competitive elections in when you do have longer terms. On the other hand, it also would contribute. Barbara doesn't like to have people who are making careers out of this business.
I left it out, Tom, not because it isn't important, because I don't think of it as an ethical issue, any more than I think of it as reapportionment, even though that's much closer,
right,
as an ethical issue. I started this stuff by saying everybody means something different by ethics. It's a government function. It's a reform issue. It's an important issue. Ethics seems to me to deal with questions of almost morality, and that's why I didn't include it.
Well, I think there's an argument that it could be a ethical issue, only in the sense that, or at least partly in the sense that you would have more competitive elections. You would have potential opponents more time to sort of develop a campaign against somebody that they don't think that were acting ethically. You would have a better opportunity to sort of have a well-financed and well-enforced public financing system if you had fewer elections. So there are some possible arguments for it.
I understand.
And that it would be connecting to ethics.
So one more question, please.
Comment and then a question for Mr. Briefault as the resident expert on conflicts of interest. So there are two ways to amend the Constitution. One way is for the government to propose a change, twice passed by the legislature, and then put before the voters. I think there has to be an election in between the two legislative sessions. The other way, of course, is for the delegates at a convention to propose a change. If those in government are delegates at the convention, then in effect, they're controlling both pathways to reform. So the question is it not sort of the ultimate conflict of interest in government for those employees of government, maybe employees of political parties, and possibly, because they're also regulated by the Constitution, employees of registered lobbying organizations, to sit as one, to sit as delegates? Is that not a conflict of interest? There have been about 240, if memory serves me right, 240 amendments, constitutional amendments since the 1938 Constitution, which were approved by the legislature. So the government recommended these amendments to the Constitution, and they were passed. But isn't it a conflict of interest for those in government, employees of the government, to be sitting as delegates at a convention, the purpose of which is to come up with a document that's designed to govern their behavior? So I'd like to hear from Mr. Briefault on that.
Well, I wouldn't say it's a literal conflict of interest, and certainly the Constitution currently permits it. I think what you're... Go ahead.
I'll comment on that. I'm not sure that it permits it. I think it's implied.
Well, the Constitution doesn't restrict who can be a delegate. Other than, I guess, I don't even know if it restricts it to adult citizens, but it's not literally, it's not part of the spirit of having it open to the public, but of course, if you look at constitutional conventions that we've had, and I think we've had, 9 since 1777, if you look at the Constitutional Convention that made the U.S. Constitution, you often have current public officials in it. I mean, they do know a lot of stuff. They have a lot of expertise in how government works. Public officials played a big role in the 67 Convention. On the other hand, they were not the only people there. So I think it's complicated. I think I would be, there might be some reasons built into the double dipping concern about getting paid twice, and there might be some concerns about that it undermines the idea of having an entirely fresh set of eyes looking at the Constitution and thinking about it. But, I think I'd be reluctant to say that people who have a lot of experience with government problems should be completely barred from participating in it. So, I think short answer is no. I don't think it's a conflict of interest. I think everybody who has an interest in the operations of government has an interest in the Constitution.
But you do agree that it's the document that governs their behavior.
Right, but it's the same thing.
And there are lots of experts
Right.
on the
Right.
Constitution, the history, meaning,
Right.
the significance of every provision
Right.
that are not in government
Yeah.
and that are reform-minded.
It's also the government, the document that,
Would you be willing to do that?
of course, but I would say it's also the document that governs our behavior.
Except we're not mentioned. The people aren't mentioned except that we adopt it. Nowhere in the Constitution. It's a set of principles to govern the government.
Everything that deals with taxation, that deals with the public school system, that deals with the rights of the ownership of private property, whether we're mentioned it or not, we're there. It's our Constitution as well as the legislator's Constitution.
That's what's there.
Okay.
So with that thought, we are about 19 months away, 19 months, from all of you and voters around the state going to their polling place and looking at a 13-word amendment that reads, "Shall there be a convention to revise the Constitution and amend the same?" I want to thank all of you. I want to thank our panelists for helping to stimulate a conversation and discussion.